Good morning, Justice Dambuza.
Good morning, Chief Justice.
How are you?
I am a bit nervous, but I will survive.
That's good. Those butterflies keep you on your toes.
Thank you.
Perhaps I should start by disclosing that you and I have known each other for a really long time, since age 14, when we started high school at St. John's College in Umtata. And we were at university together, worked together, and here we are today.
Yes, Chief Justice. It's been a long road.
Yeah. You hold 3 law degrees.
Yes. Yes, Chief
Which are
Justice.
they and where did you obtain them?
I obtained my BProc at University of Natal then, at the Howard College campus in Durban, and the LLB as well. And then I went overseas to do a master's on what used to be the Educational Opportunities Council scholarships.
The EOC.
EOC, yes. And I went to Louisiana at Tulane University, New Orleans, to do a master's.
In which area of the law was your
It
master's?
was international law, trade and finance.
And you came back and started your own practice.
Yes, I came back. I had hoped to work with some firm, but I couldn't get a job for a while until I decided to set up my own fish and chips shop.
Well, that seems to have been an inspired decision because your law firm didn't do shabby at all for those times for a black woman. As I recall, you got a lot of commercial work. How did you manage that?
I didn't immediately get it, Chief Justice. It took some time, but I think what I produced made people talk and about the kind of work that I'm doing. And one thing led to another. And my first instructions from a big client was with the First National Bank, and that was only because I went there to ask for a loan to start my practice. And then the manager then, Mr. Mtia, said, I'll give you one collection matter and see if you'll be able to do it. And I did it, and the rest is history.
But then your legal career had started before that when you were doing your articles of clerkship in Durban.
Yes,
In 1987, but you were still at university then. How did that work?
What had happened is that because when I did a BProc, I did all my law courses in my BProc degree. Remember, I started BProc at the University of Transkei, and then in 1984, when we had those upheavals, I transferred. I applied to go in the next year to Natal University. And then they made me repeat some courses, which I had done at UNITRA, such that by the time I finished my BProc, I had done a lot of courses that I didn't had to do. So when I did LLB, I had very little to do. I was doing mostly electives, and I thought I could start my articles because I knew that I wanted to make use of the fact that I was sponsored by the Transkei bursaries. So I knew that when I started my articles, there would be very little money. I mean, I think my salary was 300 Rand a month. So I was taking advantage of the fact that I had a bit of space in my studies, and also I had some funding.
All right. And you say your salary was 300 Rand a month?
It was 300 Rand a month.
That was a lot then.
Yeah. Well, you could get by.
So you ran your own practice until 2000? and then decided to consolidate with another attorney.
Yes. We consolidated with Mr. Mngandi, Philisa Mngandi, because we wanted to get some capacity, because we did continue to get, considerable amount of work. And we consolidated, and we were asked to open an office in East London. And so we did that. But it was at that time, shortly thereafter, that I was invited to come and act at the Bishop High Court then.
So how long in all were you in private practice?
I was in private practice for 12 years, Chief Justice.
And during that time, you also taught law on a part-time basis.
Yes.
Can you tell us a bit about that?
I started, I became interested in the law school, the legal training school that the BLA was running in East London. So I would go and do a week of lecturing there to article clerks as I was practicing. And whilst I was there, I somehow met the Dean of Faculty at Fort Hare University, who also invited me to come and teach at Fort Hare in Bishop in the evening classes. So I did that as well.
But then your involvement in the world of teaching did not stop at Forte. It continues to this day, as I understand it.
It does. I am a visiting professor at Rhodes University currently. So I go there and do a number of lectures in a year. I structure them in the way that is most convenient to me. And also I have done a lot of facilitation with the South African Judicial Education Institute, SAJE. From 2013 until 2023, I was on the council of the SAJE. And I did a lot of facilitation. Actually, it was short, not very long after SAJE had really taken off that I was invited.
SAJE being the South African Judicial Education Institute that's responsible for the training of and education of judges.
Yes, and magistrates now.
Yes.
And so there was a rudimentary curriculum, but we kept improving it, and we've been doing that from 2013 when I joined until now. When I started, I was just an ordinary facilitator doing, in the main, appeals and reviews. And then I became responsible for convening the new judges induction course that we ran over a couple of days after every intake from the JSC. So I became responsible for that whilst also doing my other facilitation. And then I also helped Dr. Mushweu to arrange
the CEO of the institute.
The CEO of the institute, yes, to arrange and determine seminars that judges need or require as we go on, the continuing legal education aspect division of SAJE. So I facilitated that for a while until 2022, I think, when my responsibilities in the court became a bit much. So I asked to be excused from some of my SAJE responsibilities.
So,
although I still facilitate, in other words, I don't like to say teach, but leading the discussion now and then.
Leading discussions, let's teach, and
Yes.
being responsible for the development of the curriculum of what goes on there actually at the same
Yes.
time.
Yes, definitely.
And now you sit in Sajay's council
I don't sit in Sajay's council anymore.
anymore.
I asked to be excused in 2023 um, because of my workload. So, but I just now facilitate, and I'm still involved in the environmental, particularly environmental law education, um, uh, environmental law education, which Sajay has been championing both domestically here at home and throughout the continent, which when we set up the African Judicial Education on Environmental Law, which is the continental body. I still am involved in that space and also in the global judicial education on the environment, which I was invited to through my work with the African body to sit in the board of trustees of that network of judges with interest in environmental law.
You are also a board member of the Global Judicial Institute on the environment.
Yes, Chief Justice, that's the one that I'm referring to.
Is that the one?
Yes, that's the one.
What is it that you do with in New York with Pace University?
Oh, that is, I am a trustee in Pace University. It also invites me from time to time to go and lecture. What prompted this is in 2022, when the UN recognized the environment, the right to the environment for the first time, passed that resolution. Because South Africa has always had this clause in our constitution that entrenches the right to a clean environment. So they asked us, me, I have been there together with Dr. Mshweu and sometimes myself, through Pace University. They asked us to go and share some of the rights jurisprudence that comes from this jurisdiction. Basically, not necessarily on the environmental law space only, but the right to health care and all those cases that came out of our constitutional court in particular in the 2000s and early 2010s, 2010 to 2015. Because the reasoning, the entrenchment of the right works more or less the same way.
Um, you have chaired the African Judges Education Network on Environmental Law. Is that what you talked about earlier?
That is
so you were not just an ordinary member there, you actually chaired that body.
I chaired it for 2 years, and actually we did quite well as Sajay in chairing that. I chaired it as a representative of Sajay, because Sajay was asked to chair it when it had become stagnant. And we did manage to revive it, and I did my 2-year chairmanship stint, and we left it on a very high. I'm not sure what's going on now, because the politics had started creeping in, and we thought we want to back off a little bit.
It's a pity. You're a jury member. So in the global space on environmental law, you're a jury member of the Elizabeth Hobb Award for Environmental Law and Policy. What exactly is that?
It is the body that recognizes, it was set up by some family in New York. It recognizes persons who have made a significant contribution to the advancement of environmental law. Yeah.
All right.
So they are honored once a year. It's usually one or sometimes two people, depending on what has come through. For example, this past year it was John Knox, who's a lawyer and also has worked a lot with the UN on environmental law.
All right. And you've managed to deliver 3 papers in that space during all this activity and your judicial work.
Yes, Chief Justice, I have managed to, and I think it actually is more than 3 papers because a lot of work was going on when I was the chair of the African Continental Environmental Law for Judges body. As chair, you get asked to speak in all sorts of places. Then I think, again, because I came from South Africa, and again, because of the jurisprudence, because that's what colleagues would tell me, would want to hear about how we do things, how we interpret our constitution, and how things are panning out.
All right. We skipped two not so tiny details before we got to the Sajay. You were also involved with the Walter Sisulu University. I remember during a very troubled time for that institution. What exactly did you do there?
I was the chair of the council there. I started also with the BLA continuous education program, going there during recesses to just teach them article clerks from the surrounding areas, not only from to the Transkei, University of Transkei section then of what is now Walter Sisulu. So I would go to Mthatha and teach article clerks, for a period of a week. And so I got to know people, and the university went through some turbulent time in the I think late 2000s, and it went under administration. And when it was ready again, I was asked to chair the council that would then sort of instate it to and take it forward, re-establish sort of together with other council members, the university council. So I ended up chairing the university from having done these lectures and gotten to know people, particularly in the law faculty.
Did you and your crew have any luck with bringing things back to even Kio?
The university?
Uh-huh.
Yes, I think we did make considerable progress and stability in very difficult circumstances. But we managed to move the finances of the council, the university, from nothing to a bit of at least positive, and we even started saving some money.
There is also the work you do at Nelson Mandela University, which you have not mentioned.
Oh, yeah, there I just chair the council.
Just chair the council.
Yes, Chief Justice. I have been chairing the council for, this is now the 2nd year.
All right. Now,
that's my hometown university.
Yes.
So they managed to twist my arm, even though I had thought I'm
getting
out of the space. Yeah.
Just back to Sajay quickly, but this is important. The Sajay has an illustrious journal, law journal, and there's also the book which it produced very recently. Can you tell us a bit about those milestones?
Yes, the journal I can't remember now when we started it, but we managed to get it. The aim was that we would have 2 publications a year. But I know that that hasn't held through because, judges are very busy. It was established as a sort of a space where judges can express themselves with the support of SAJE. Outside the confines of the pleadings that they adjudicate on all the time. But it is still going on, I understand. But I am no longer involved in the journal itself. But in 2020, in 2019, 2019, in anticipation of the 10th year anniversary of SAJE, the CEO, Dr. Mushweu, approached me about a book project that she's thinking of, that we could have a 10th anniversary book in celebration of the 10-year anniversary of SAJE. And because I was still very involved then in judicial education and also still a member of the council, I agreed to sort of coordinate and facilitate this book and talk to judges to write. I wrote in Justice Madlanga to assist me because it was a big project. But after some time, because of his work commitments, he couldn't assist me anymore, and I tried other people. I ended up doing the editorial work myself. And although we missed the mark, we missed the point in that the anniversary was in 2022, we only managed to finish that project earlier in the year, and we launched, as you know, Chief Justice and other members and I see President Mulimel were there for the launch. That was just in August before we started our court term. So that book is out over and above other editorial journals and publications that SAJE runs. Yes, yeah.
Just to round off on your extrajudicial activities, you were once a council member of your Law Society of the Cape of Good Hope back in your other life as an attorney.
Yes.
Currently, and at some stage, you were a member of the Judicial Conduct Committee.
Yes.
And now you are chairperson of the Rules Board for Courts of Law since 2018.
Yes, Chair.
Okay. You can't possibly still be nervous by now.
This is a big room, Chief Justice.
Let's go to the meat of your CV, your judicial work. So you started acting as a judge in April 2003 in the Eastern Cape Division of the High Court.
Yes, Chief Justice.
And acted until your permanent appointment in 2005.
Yes.
And you were in that court until May 2014.
Yes, Chief Justice.
But you had interposed your judicial career because in 2009 you were appointed to the Competition Appeal Court.
Yes, yes.
How long did you remain in that court?
I remained there effectively for just over 2 years, Chief Justice. I think it was 9 terms or 10 terms. Because then when I started in 2009, in 2012, I went to act at the Constitutional Court. And from there, I never effectively went back. I acted at the Constitutional Court for 2 terms, and then I went back to my court for a term. But before I got my allocation for that from the Competition Appeal Court for that period, I was invited to go to the SCA to act there.
You had been invited to the SCA before you actually went to the Concord.
Yes, I did.
I saw in the record that Judge Mpati, the then president, was not happy about that.
Yes, it was a cause for a bit of discomfort.
So these two courts were fighting over you. You acted at the Constitutional Court for, was it 2 terms?
Yes, it was 2 terms, 2013 in the last term, November term, and then I acted in 2014 in the first term up to March, on the 31st of March.
All right. And there was a high expectation that you would make yourself available for permanent appointment at the Constitutional Court at the time, I remember. But then you chose to go to the SCA. May I ask why?
The expectation, I was not aware of it. I went because I had promised Justice Mpati that I would come after my stint at the Constitutional Court, which I did. But when I got to the SCA, I thought it would serve me well, it would be beneficial for my career for me to start in that court. Because going straight from the High Court to the Constitutional Court was a bit of a culture shock for me. I mean, in the High Court, you're used to running your own court the way you want, you write your own judgments. So from there, of course, you do sit in full benches and full courts, but the rigor is not as much. But from there to working with 10 other colleagues and, the level of what I think could be an intrusion into your writing space and how you conduct your things was a bit of a shock. I thought when I got to the SCA, where I work with 4 other colleagues, it's a better space to familiarize myself with the art of a collegial court continuously, and also the working systems were very different, and I thought it would be best for me to start in that court. The pace of the production of work, and I thought it would be a good training ground for me, so that if I went to the Constitutional Court, I would be a better person, better judge, or add value, rather than being babied around until I found my feet.
Looking back now, are you happy you chose that detour?
Yes, I'm quite comfortable with that detour. I would do it in that fashion again, given a chance.
So you acted for a year at the SCA from 2014 until your permanent appointment in 2015.
Yes.
And you've been at the SCA to date.
Yes, I have been at the SCA now for about 11 years.
But then, yes. And in that time, you have once more returned to the Constitutional Court to act for another 2 terms?
Yes, Chief Justice. You invited me to act in the last term of last year, 2024, and then another term it was the first and second term of this year, until the 31st of May.
How did you find the experience this time?
The experience was much better than last time. I think I knew what to expect, and I was already steeped in the culture of a collegial court and appellate decision making. There's much more work than there was before when I was there in 2013, 2014, way more. Um, and so the work is just relentless. Those applications for leave to appeal keep coming, and the, the, the decision-making process is slower than I'm used in the SCA, of course, because judges they have got to make it's an en banc sitting court. Also, for every decision, judges have got to work together. But it is quite a rewarding kind of work. It is very exacting. Uh, you are held accountable by your judges to a larger extent. And perhaps because in the SCA, I have grown to be one of the people that are regarded as senior, it is quite humbling when you really have to go back to accounting at that level with everybody else.
Well, you're not just one of the senior judges at the SCA. You acted as the president of that court for a while, not so?
Yes, I did act as a president of the court for a term, and I also, after you had left the court, CJ, I acted as the deputy president of that court for 3 terms, I think.
How did you find the experience in the leadership space? And what lessons, if any, did you learn from that?
I learned, actually, that's when I realized that I would have to jettison some of the side projects that I was involved in because as a leader of the court, you have other functions as well to see that in support of acting President Betseden, that the role works well. You are there to support him when there is a problem, and you are there to raise your hand if there is work that needs to be done. And also because now I found myself propelled from, I think, being number 5 at the time to being number 2 and then number 1, meaning that you preside in all the appeals that you sit in, both at number 1 and number 2. So the responsibility is huge in that you've got to see to it that members of your bench are productive and you can help and you need to be proactive. So you need to be focused. So that the experience that I took from there is mentoring colleagues, but still being on the same plane as everybody. It is a balance that can be very fine to strike, to sort of chart the path, but not impose yourself on colleagues' space and independence to make their own decisions or to write their judgment in the way that they feel expressing themselves. That's in the main the experience that I got from there, that I'm still getting even now because I'm still high up and preside on almost all the appeals that I sit on.
So, female leadership is commonplace at that court,
Absolutely.
it seems.
Yes.
And I was surprised to realize that there are actually more women judges than male judges in that court now.
Yes, we finally managed to attain
come a long way.
that good work, actually, to you and Acting President Betseden and President Mulimela
Yes.
for keeping on giving women a chance to come to the court. And in fact, I remember that you had wanted me to come to the judiciary even when I was practicing, and I kept, uh, ducking that responsibility.
Yeah, it was a struggle to get you on the judicial path, Justice Dambuza. Uh, how many, well, you've written judgments in the High Court, in the Competition Appeal Court. Have you acted in the Labor Court?
No, I never
No.
acted in the labor court, although Judge Mlambo came down to the Eastern Cape to invite me, but it is at a point where I had made a promise to myself and to my children that I would not leave them anymore because of an experience I had while I was acting, and came home to find that my helper was selling alcohol from my house, and
Oh,
that shook me. I found my house that it was a shipment unknowingly because I used to come home from Grahamstown on weekends, and then when I gave her leave, people still came to buy. So that's how I got to know. So when Justice Mlambo, the DCJ, came to invite me, I asked to be excused because I just couldn't at the time.
trials and tribulations of working mothers. So you've written judgments in the High Court, Competition Appeal Court, the SCA, and the Constitutional Court.
Yes.
Toting all that output, how many judgments would you say you have under your belt?
I tried to look, Chief Justice, but I got the figure of 425, but I found that some of what Safli has put under my name is judgments in which I was sitting with other colleagues. So I couldn't filter that to get my own. But I would say more than 200,
It's a handful.
including because judgments that we write in criminal trials hardly find their way to
Yeah.
these publication platforms. But we do a lot of work especially as a trial judge in the high courts. We do a lot of work there, and we write a lot of review judgments that never find their way to publication. So it sometimes is difficult to set out a definite and truly reflective figure.
Yeah. You will turn 61 soon. How long does that give you to still serve on the bench until retirement?
If the court would have me, I would have at least 9 years to serve until I'm 70. I can go on until then.
You are in a healthy state.
Yes, Chief Justice.
Do you
I
still
do.
run?
No, I don't run
Races?
anymore. I just walk. I do a lot of walking. I gave up. My knees gave in.
Thank you, Justice Dambuza. I will now
Thank you,
hand
Chief
over
Justice.
to the commissioners to put questions to you. Any questions, colleagues? President Mulemela.
Thank you very much, Chief Justice. Good morning, Justice Dambuza.
Morning, President.
How are you?
I'm well, thank you. And how are you?
Well, thank you very much. Section 174, subsection 2 of the Constitution states that there's a need for the judiciary to reflect broadly the racial and gender composition of South Africa, and that this must be considered when judicial officers are appointed. Would you say it is essential for the complement of judges of the Constitutional Court as the apex court and as a court that was established now more than 30 years ago, would you say that it is essential for its complement to reflect gender representativity in particular? Thank you.
Thanks, President Miller. Yes, I definitely would say so. I think presently the court has for women and for men. And I think it is well poised to implement that requisite in Section 174. And therefore, it would enhance the confidence that people would have in the court, in seeing that it truly represents what obtains in their communities. As a leading court, we need to ensure that in as far as that can be done, it is done.
Thank you very much, CJ.
It is 5 men, actually.
Is it 5 men?
5 men and 4 women.
Oh, 5 men and 4. You see, it is even more important. There's a deficit.
Yes, thank you very much. CJ, I know that we are limited to 2 questions. I'm asking now my second question, but it has a few elements. Okay, so I am asking this question, which relates to the jurisdiction of the Constitutional Court. It's provided for in Section 167, subsection 3B of the Constitution. And some people refer to it as the clause that gave the Constitutional Court general jurisdiction. Now, can you maybe just inform us about the provisions of this section in terms of the jurisdiction of the Constitutional Court? Let's not talk about purely constitutional matters. Which other matters that are not of a constitutional nature may it adjudicate?
That are not of a constitutional nature.
Nature,
Okay.
yes.
Let me say, President, that in a sense, as the Constitutional Court tells us all the time, that the Constitution permeates all areas of our law. And I think that is the mindset or the unwritten policy that the court assumes when determining which matters to assume jurisdiction over. And therefore, the range of matters that it has assumed jurisdiction over range from matters where interpretation of a law or statute is required to matters that are of general public importance. So those have been the guiding principles in matters that do not fall within the exclusive jurisdiction of that court.
Yes, the section refers to matters of general public importance in which arguable points of law are raised. Would you be in a position to maybe give 2 or 3 examples of what you would regard as an arguable point of law that is of public importance?
An unarguable point of law would be of public importance would be an issue that arises from the pleaded case that is not confined to the litigants in that case. That is of general, as the principle spells out, that is of general, that impacts on the wider South African society, that is not confined to the immediate litigants and perhaps a few others close to it, and a matter that impacts on the understanding of a particular law, of the interpretation and the meaning and the impact of a particular law that impacts then on the wider public, wide community.
Thank you. Thank you very much, Justice Dambuza. Thank you, Chief Justice.
Thank you.
Thank you, President. Commissioner Mwima?
Thank you, CJ. Good morning, Judge Dambuza.
Morning, Commissioner.
Just one question from my side. Judge Dambuza, the Chief Justice in celebrating the Constitutional Court's 30 years journey made a pronouncement as follows, that this celebration is not only about honoring the past, but also about looking to the future to a continued commitment to constitutionalism, human rights, and justice for all. And I believe this proposition made by the Chief Justice is she's following on the footsteps that were developed by her predecessors. Now, the question that I want to pose is, what is your appreciation of these three concepts: constitutionalism, human rights, and justice for all, and how will you help the Chief Justice to implement this vision for the next coming 10 years? Thank you.
Thank you, Commissioner. I think the values that you refer to are some of the values that anchor our Bill of Rights. That when the Chief Justice talks about constitutionalism and within the context of those values, meaning that these are our guiding light when we do our job, in as far as that pertains to us as members of the judiciary. These are values that we will take forward into this future and perhaps take them to even higher heights in doing our job and in interpreting the law and adjudicating the cases that come before us. It is the values that focus our decision-making process that we must not forget. And therefore, like my colleagues, as the Chief Justice said, it is values that henceforth one always has to evaluate, how can I do this better in the context assisted by these guiding principles. We have been doing this job for decades past. I have been doing this job for over 20 years, but there is always room for enhancing the process, enhancing the product, the judgments which have an impact on people. It means we have always to be searching for how we can still anchored in these values, do our job better, you know, to keep on doing, meting out jurisprudence that is aimed at improving the lives of South Africans.
Thank you, Judge Dambuza. Thank you, CJ.
Thank you, Chief Justice. Good morning, Judge Dambuza Mayos.
Morning, Minister.
How are you?
I'm well, thank you.
I'm
I
okay.
hope you are
I'm just
too.
following up, and perhaps maybe it will go into what I put as a question. Listening to what you say, you've got quite vast experience, your knowledge coming through, looking at how you've been able to cover such areas as sexual violence, accountability, but also just, yeah, you spoke earlier on about the work you do in terms of environmental law. Looking at all those, where do you think that we should be able to focus as part of us widening access to justice in the country?
I'll say, Minister, I also sit in the, as you know, in the rules board. We work together. And I always think that how we construct the rules, how we make provision for what should happen to costs, how we use technology. I think in the areas that I am involved in, I would say the rules are the engine room. They are the engine room of the judiciary. They direct how courts work, the procedures that we determine there have a wide impact on access to justice. And I think that's where we can focus. How we allow people to come to our courts is at the heart of access to justice.
Indeed, your work in terms of being the chairperson of the Rules Board, it is acknowledged, Justice Dambuza.
Thank you very much, Minister.
Commissioner Professor Marumahai.
Thank you very much, CJ. Good morning, Justice Dambuza.
Morning, Prof. Morning.
I have two questions for you. The first question, it relates to what appears to be your passion. There has been some criticism, I'm not sure if it is warranted or not, that the Constitutional Court has not yet meaningfully engaged Section 24 of the Constitution, and that we need serious guidance on how environmental rights and various aspects, including water and all those, needs to be dealt with. And in particular, when one looks at the need for business to operate and to create jobs. On the other hand, the health concerns and the procedural rights that are or procedural requirements that are needed for business to operate and the balancing of those rights. I see that this year you wrote a wonderful judgment, Minister of Environmental Affairs versus Trustees, that dealt with ESCOM and what they wanted to do at Richards Bay. And it seems to me that you were able to look at the health aspects and their lack of following the procedural rights. What I want to understand is, should you be successful, how should those tensions be properly balanced? The need to understand adequately the environmental concerns, while on the other hand, there is this unemployment and the need to do business and all those kind. How do we balance that kind of tension in the country?
Thank you, Prof. Thank you, Commissioner. What we realized in that case that you're referring to is that there seems to be a gap, perhaps, in the administrators in understanding that they have a an important guiding tool in the National Environmental Management Act. It hasn't been invoked much when interrogating the decisions that government officials do. And it seems that public officials were of the view that once a policy is determined, for example, in that case, on the part of ESCOM, once a policy is determined that we do not have electricity and therefore we need to add so many megawatts of electricity, they are oblivious to the guiding principles that are set out in the NEMA Act, which actually talk to what you're asking about, that all decisions where there is likely to be a significant impact on the environment, the principles set out, especially in Chapter 2 of Section 2 of NEMA, have to be applied. In other words, the decision-making process has got to be made up through the prism of those of those guiding principles. Applying caution, because science changes every time, we don't know what might happen. But us as courts, there is a level to which we can't go. We can't say that to a public official, this is how much, when the scientist says the emissions are likely to be to this extent and cause this damage, then this is how you decide. What we as courts, we are duty bound to do is to ensure that all the relevant principles, you've got to take into account what the emissions are, you've got to take into account the context that you are living in South Africa. Actually, job creation is part of the factors that are also referred to in NEMA. So the balancing act will be done by people who are properly qualified to do that. All we do is to ensure that they do so, and it's got to reflect in their decisions that this is how we came to this conclusion. We took into account, we were cautious, the public participation procedures were all adhered to and meaningfully. And although perhaps the emissions are likely to cause this damage, at this point, we feel that this factor, which might be the need for power, leads us to the decision that we take ultimately.
Thank you very much, Justice Dambuza. And also the issue of corruption comes into play in these matters.
Sorry, then?
I was just saying the issue of corruption comes into play on these matters. But I need you not to comment on that. Let me ask you my second question. When you were engaging with President Molemela, and you were dealing with the extended jurisdiction of the Supreme Court of the Constitutional Court, I was not quite sure if I understood your answer. I want to give you an opportunity to reflect on it. My understanding is, and please correct me if I'm wrong, in the case of Paulson versus Slick Nod investment, that's where the Constitutional Court actually tried to explain to us what this particular extended jurisdiction actually means. And in that court, one of the things that the court said was it has not yet laid a basis upon which we can understand what really this public interest or general actually means. So what I want to understand from you is, is there a particular guideline that the court should use in order to determine that when a matter is before it, it has actually met this particular criterion of this extended jurisdiction, that is a non-constitutional sort of matter jurisdiction?
Oh, Prof, I thought the principles themselves that the determination of the impact of the likely decision is itself a guideline. These cases are the constitutional assumption of jurisdiction is determined on a case-by-case basis. And the best I can put it is that those guiding principles are what one takes into account in determining whether the issue is an issue that requires the attention of the court, in the sense that either it will impact on the wider society, or it entails interpretation of a law or a statute that, if left misinterpreted, would result into a negative impact on its application in cases that follow.
Thank you very much, Judge Dambuza. I think it's important that the starting point is whether it is of general public importance, then
Yes.
everything else follows
Okay.
thereafter. Thank you very much, CJ.
Commissioner Hassan?
Thank you. Thank you very much, CJ. My name is Fasiha Hassan. I find myself in the JSC as appointed through the National Assembly. Judge Dambuza, thank you so much for coming today. It's always wonderful to see Black women in particular who have such strong credentials coming to interview before us. I have two questions. My first is related to technology in the law. We're currently in this digital age, and it presents new challenges, particularly to rights such as privacy, freedom of expression, equality, etc. I'm interested in your thoughts on how the Constitution should be interpreted to address issues such as data privacy, algorithmic biases, or maybe even the regulation, potentially, of social media platforms. That's my first question, CJ. Thank you.
Thanks, Commissioner. That's not an area that I'm very strong in, but I know that the Judicial Education Institute is involved in a project to familiarize judges with the developments in the world of technology. I suppose the Constitution, being a framework really, would not particularly talk to areas of that kind of development, except insofar as aspects in the Bill of Rights, say, for example, freedom of expression and communication within that extent, context, and the right to dignity and how it may be impacted negatively, and the vastness of the extent of communication and the impact thereof on people because, of technology. Things like social media and how that impacts on the rights that are protected in the Constitution. So in the decision-making process, I'm sure it is a matter that we would have to filter through that what used to be something that would be communicated to 2 or 3 people can now go to millions, and the impact on the dignity um, and the life of a person may be violated in a fundamental way. Thanks.
Commissioner, CJ, can I come in here? Judge Dambuza, I think you are being too modest. Under your leadership, the Rules Board dealt with courts having to proceed and operate under COVID-19. That's the use of technology. Maybe share that experience, because I think that was a fantastic job that was done to enable continuity in the midst of lockdowns and all that.
Oh, thank you. I had not thought of that. Yes, we in the Rules Board, we from the time of COVID, we had to quickly cobble together rules that would enable the courts to function within that context. And I didn't think of that because the rules haven't gone to promulgation stage because of the problems that you and I know about, Minister. So they're not out in the public domain. But technology indeed does bring access to justice, as we saw during COVID. And therefore, access to justice, Section 34 of the Constitution, is impacted. And it is in that line that we're trying to have the rules formalized so that technology can be used to enhance access to justice and the lives of people. I know Justice Mlambo also champions the use of technology, and I think the use of case lines in our court has revolutionized how courts function, and this can become better with time.
Thank you very much, Judge. My second question is related to the reserve judgments that you cite in 16.4 of your questionnaire. And of course, the question must be asked, I think, given some of the previous challenges, which you have, I think, succinctly explained the previous case, I think, when you were acting in the Concord, but of course it was in a different division in which the challenge happened. But the question is around the status of these reserve judgments. Where are they? And what interventions you've put in place to prevent a delay of 2 years? I mean, I understand there was an exceptional circumstance, but what interventions have you put in place to ensure that this doesn't happen in the future? Thank you.
Yeah, that was quite an unfortunate incident. Thank you, Commissioner. The judgments that I put out in the as reserved, outstanding, 2 of them have been handed down. The one is the one that Prof. Marumo Achaye was referring to, the ESCOM versus Minister of Environment. And the Woolworths ones. The measures that I have put in place are just keeping a schedule of my judgments and knowing what is outstanding. That matter that referred to happened in 2011. Is a case that I had in 2011, even before I went to the SCA. And it is unfortunate that the file went to the registrar's office and it was filed there. And because I had not kept that kind of schedule, we normally kept our files that are outstanding in our chambers. But because the registrar that I was working with was a new registrar, she just took all the files to the registrar. And I think because of the pace of work, that matter simply escaped my mind totally, to the extent that even when I was alerted to it, I was sure that there was a mistake because it's not a matter that really happens, and especially at that time. I do keep a schedule.
Sorry, CJ, just to confirm. So of the 6, 2 have already been handed down.
Yes.
The 4?
The 4, 2 are from my acting stint in the Constitutional Court now, up until May, and 2 are from my court, and 1 is finalized and will be handed in next week, and then the 1 is the one I'm working on right now. Thank you.
Chair, arising from,
Follow up?
yes, from the question from Commissioner Hassan. Good morning, Chief Justice. Good morning, fellow commissioners. Good morning, Justice Dambuza.
Morning. Morning. Morning,
Yeah.
Commissioner.
Now, arising from your response, we know that during the last interview for the position in the SCA, there was a question that was posed, I think, Professor Slemmer, who informed you that some of your judgments have been handed down, took 10 to 7 months to be handed down, which you can...
Sorry, Commissioner Konyane, would you just bring the mic closer?
Oh, sorry,
I'm
sorry,
hard
sorry.
of hearing this morning.
Sorry. During your interview for the SCA position, a question was posed to you from Professor Schlemmer, who informed you that some of your judgment, which handed down, took 10 to 7 months to be handed down, which the candidate, you confirmed that indeed there were instances where you found that you had delayed in handing down the judgment. Now, the question which arises from your response is that, may you then tell us what is your turnaround time to hand down judgment ever since then?
It's difficult to say what the turnaround is, because now what I have tried to do, we get allocated, for example, I'll talk about what happens in the SCA. You get an allocation of 2 judgments in a term, and you write those judgments, and in the next term, like that. So you'd find that some of the judgments entail quite intricate issues, and they take longer to write. So in some terms, you will find that there's a judgment that I can hand down within 4 weeks. For example, there's one that I'm going to hand down that was heard now in October. Now it's ready to be finalized. But there are judgments that take longer, and whilst you're writing them, there are other responsibilities that you attend to, which sort of tend to interfere with your writing, your thought processes. The difficult judgments, if I could have my way, you wish you could just have 3 weeks of not doing anything but writing that judgments, but you don't get that kind of leeway. You've got to help your colleagues as well at the SCA, and also you've got to do your reading during the recess in preparation for the next term. So it does happen that judgments get delayed in that fashion. I will admit that. But one thing I can guarantee you, Commissioner, is that there is no time that I'm not working on a judgment. No time, no night, no day, no weekend. I mean, I think most of us work like that in that court. If you go on Saturdays, you'll find there's everybody there. We work on these judgments, but you'll find that we're still struggling to get to hand down judgments at the end of term. I've almost given up on doing that. Something that I used to be able to do from 2014 when I started in that court until 2022. It was a given that all my judgments would be out, or if not out at the end of the term, they would be out during the course of the recess. But I do find that I am struggling to handle that. And it's a matter that we have been trying to resolve and find ways around. But if you were to take the judgments that I hand down very quickly, the low-hanging fruit judgments, and the long ones, I would say average 3 to 6 months.
Thank you, CJ.
Please on that. Good morning, Judge.
Morning, Commissioner.
Judge Dambuza, in the questionnaire, you are asked at 16.4, and it is this discussion that you are having now, at 16.4 to list the reserved judgments and the dates on which the judgments were reserved. You listed the judgments, and I note that you say 2 have already been delivered, but you don't say when the date when they were reserved, but also from your discussion, one doesn't get an explanation to where are things with these judgments as matters stand, and is it a function of you delaying, or is it because you sat as part of a bench, and it's somewhere in the system, it's off your hands, but it's somewhere in the system of getting the judgments finalized. If you would just say more about that, and I guess it's a topic of interest because the court to which you are applying increasingly is getting criticized for delays or is the subject of comment about delays in judgment, recognizing that the workload of that court has exponentially increased. So if you would just give us a sense of contributing factors here, but perhaps looking forward, what it is that you would suggest should happen in the Constitutional Court to assist with reducing the lag in the periods for delivery of judgments. Thank you.
Starting with the last point, Commissioner, thank you. I am aware that the Chief Justice and the judges of that court are in a process of facilitating an amendment to the Constitution that would enable the judges of that court to deal with matters not en banc necessarily, particularly the applications. I am not privy to the extent of which the amendment is likely to also impact on the workings of the court, of the sittings in open court. I think that that initiative is likely to release the working capital of the court and release the pressure of having the decisions made by all the judges and have 2 courts, parallel benches, working at the same time and making decisions at the same time. That is what happens in the SCA in relation to applications for leave to appeal, and it works fantastically. It is difficult to make a suggestion, Commissioner, on generally how the other decision-making processes in judgment production should be streamlined. And I'll make you an example that sometimes, from my experience, even when judgments are ready, or well, a draft has been produced and colleagues have commented to it, and the judgment is almost finalized. It happens that it takes one comment to sort of deconstruct the whole process and the judgment writing process has got to start again. I think it is a function of a decision to which many people contribute. As long as that decision-making process in that court has to consist of 11 judges all the time, I think it's going to be difficult to get things to run faster. But I know that there are attempts to do so, and perhaps some of the pre-writing processes could also be sort of jettisoned or looking into whether all the contribution, the process of contributing to a person's judgment have to, be kept in the fashion that they are now. I am not able to contribute further than that in regard to the Constitutional Court. Regarding my note, you are right, and I apologize to commissioners for that. I did realize that I hadn't put, when I was revising my form, that I hadn't put the dates of these judgments that were reserved when I put the reserved judgment on my on the form. I was just remiss in doing that. But in as far as where they are, as I said to Commissioner, I think Commissioner Moiman, I am working on them. It's quite a challenging situation because I'm working on the Constitutional Court judgment, one of which I thought I had finished, and then some comments came through again. So they are all on my desk. I am working on them all the time.
And perhaps just to add to Justice Dambuza's response on the delays, especially at the Apex Court, and the proposed constitutional amendment that will allow the court to hear other matters not sitting on bank, which it's been discussed at this forum many times. We've heard over and over how that just bogs down the systems. The constitutional amendment is in the pipeline, and we rely on the minister to ensure that it is fast-tracked. It was delayed by the elections and the change in administration last year, so we had to wait, and we are in the hands of those that process these things. But then that constitutional amendment, when it does happen soon, hopefully, will not be the be and all. It won't be the complete answer. Challenges with expeditious, administration of justice, they exist across the board, from the apex court down to the high courts. And one of the key reasons is that there's been an explosion of litigation in the recent while. There is just too much work. And unfortunately, the number of judges remain the same as it was 15 years ago. We had Justice Dambuza explain that at the SCA, they work all the time. Judges work extremely hard every day. We don't sleep. I'm exhausted sitting here. But there's just too much work. And in many courts, there's inadequate support. We've been saying these things publicly, and hopefully now that there's going to be institutional independence and the judiciary will manage its own budget and hopefully get a bigger slice from National Treasury will be able to prioritize, the necessary support measures, such as researchers, which the SCA has been fighting for, and essential staff. So it's very complex, but judges, and I've no doubt, Judge Dambuza included, work very hard. They don't delay judgments deliberately. It's because there just is too much work. I'm sorry for that emotional outburst, but that's just how it is. Minister, then Commissioner Pillay.
Thank you very much, CJ. I will not be tempted to get into that discussion. But let me just ask Judge Dambuza, during your interviews for the SCA position, it was seen that the judgments that were reserved almost around between 7 to 10 months, and this was raised during your interviews. So roughly how long does it take for you to deliver in your work judgments?
After that long explanation, thank you, Minister, I'm sorry. The explanation that I gave to the commissioners, Commissioner Nonkonyan and Commissioner Maiman, I have come to rest at 3 to 6 months. I'm not sure that that's accurate, really, because there are judgments that I hand down in a period that is much shorter than that. But there are judgments that indeed exceed the 6-month period to 7, 8 months. And I have had a judgment that went to a year and a year and 2 months. But that comment that you're referring to, Minister, referred to High Court judgments. The working system is different in the SCA, where I am now. And the judgments that I've explained how the intervening responsibilities affect the judgment writing problem. If you look at the profile of the judgments that take long, you will see that it's judgments that are really complicated, that involve many different issues that one has to determine. It's not an issue that is limited. Those are the judgments in which there's one issue that arises. I definitely hand down within no time, even ahead of the set periods. But we have been finding it increasingly difficult to finalize those judgments that entail many issues, particularly if you are in a position where you have to look at other people's judgment and try, to assist. For example, acting judges that come through the court would often ask you as a presider to look at their judgments before they circulate. And then that process on its own sort of derails you from your own judgments. And it is a responsibility that we have to do. It's a practice that we found there that has happened. However, if you remember, during the period 2020, 21, 22 even, we lost a lot of experience in the court through attrition, retirements, and elevation to the constitutional court. And therefore, there had to be a lot of, quite a bit of complementing the complement of the court. So we are not as fast as we used to be in handing down the judgments. And for some of us like me, if there are these other responsibilities, they impact on the rate, on your output of your work. I honestly, Minister, can tell you that, speaking for myself, there's absolutely nothing else that I can do. I mean, the president can bear me out. We work all the time in that court, and we work on weekends. But somehow we are battling um, to hand down the judgments as soon as we would also like to. And believe you me, this is something that, as a judge, you would want to do. You would want to hand down your judgments. It is a matter that sits heavily in your head and in your heart. If you've got outstanding work and you know that more work is coming in, but we're doing our best. That's the best I can say.
Follow up, CJ.
Then Commissioner Matolo Lepu, followed by Commissioner Steinbeck.
Thank you, CJ, and good morning, Judge Dambuza Mayusi. I'm here.
Oh, yes.
Okay. Mine is not a question. I'm just trying to find out. I want your input, so to say. It's a lot of litigants are now coming to the Concord for direct access, right? And most of the matters are dismissed. And I always wonder when seeing all these matters going to directly to the Concord being dismissed, is it because the practitioners or litigants don't understand what needs to go to the Concord, or what can be done? You know, because I think maybe it adds up to the judgments being delayed because we have to deal with this direct access to court. What's your opinion?
Commissioner, I think it is an incident of opening up courts to people. They will use the opportunity to see whether they can get a different outcome from a different court. When I was serving in the Judicial Conduct Committee, Commissioner Matololepo, you'd be surprised that forum is used sort of as an appeal court as well. And that's one of the burdens that increased our work, people that were serving in the Judicial Conduct Committee, because when people don't get the outcome that they want, they will go look for another avenue. And in instances where one does not necessarily have to go through an attorney, you will get more and more of those kinds of litigants wanting to have a rehearing of the matter. It's got nothing, I don't think it's got anything to do with the practitioners. Practitioners know what the law is, what the chances of success are. But when you have a desperate litigant where a decision is a matter of life and death, I mean one way or the other, there will be a push to have another bite at the cherry. It's just an incidence of having a forum to go to. That's my thoughts.
Thank you.
Commissioner Mangena, followed by Inkosi Longonyana.
Good morning,
Morning, Commissioner.
Justice Dambuza. On the contrary, I'm one of those who think that your work rate at the SCA is impressive.
Thank you.
I've commented to the president that I don't know what she has done, but we are seeing an improvement in terms of the turnaround time regarding the delivery of judgments. Thank you for that work output. But then I've got a question for you regarding the court that you want to be elevated to. There is generally an outcry or a perception, if you may call it that, wrong or right, that the Constitution has not been interpreted in a way that advances the interest of the previously disadvantaged people in our country, more especially in relations to issues of land and BEE. Firstly, do you agree with that perception? And if you agree and you are to be elevated, are we likely to see some change in that approach?
Thanks, Commissioner. I would not quite agree. The court has done quite a significant, the judgments of the court have resulted in a significant change in the lives of people. What I would say is that there is always more that can be done. The court has protected the right to life. It has afforded medicines to the TAC judgment, Treatment Action Campaign, and other similar judgments. The court has interpreted the Constitution to affirm the right to children at schools to have sustenance. There's many of cases where the courts have affirmed rights and advanced the rights of people. I know there is a contention on the minimum core that the courts should provide for. The Constitutional Court should sort of stipulate that a right to a house, for example, means a right to a 4-bedroom house or 2-bedroom house or whatever. And that is one of the areas that the court has refrained from doing so. And I suspect that when a proper case supported by a proper, the necessary substance, the court doesn't know what the budgets of the government are. So there's a level, there's an extent to which the court cannot go, and I think that's where the controversy is. But to say that blanketly the court hasn't done nothing to advance, to improve the lives of people, I think is an overstatement. I don't think that that's right at all, that's correct at all.
Perfect. My second and last question. You were in the Constitutional Court in 2014, round about there. And when I looked at the judges that you worked with in 2014, there appears to be only one remaining now, Justice Mhlantla. Mm-hmm. The rest of the judges have retired. And now in 2024, 10 years later, you found a new crop of judges.
Just pull the mic closer to you.
Now in 2024, you found a new crop of judges. Given that time lapse and the way the Constitutional Court worked then and it's working now, do you see a change in approach on issues of interpretation in relation to issues of precedents and the commitment to depart from certain judgments to give effect to the Bill of Rights?
Starting with commitment, the commitment is the same. It's the same, if not more. The change that is significant is in as far as the work of the court is impacted by the extended jurisdiction, because when I was there, the Superior Courts Act had just been passed, and therefore the general jurisdiction effects had not yet come through to the court. So the variety of work was more limited than there is now. But the level of commitment to the Constitution, to the Bill of Rights, is the same. And I would say even more improved, because like in any job, your thinking processes, your reasoning processes and other avenues become enriched by the experience that you've had, by further inputs that counsel that appear in that court have had. Because I think from the level of the side of the practitioners as well, they are constantly seeking and ways to enhance their input to the constitutional project. So in that sense, that work filters through to the courts, and the court has now, I think, ventured into other areas, dug deeper into the issues than it would have 10, 15 years ago. So in a nutshell, the level of commitment is the same.
Thank you, Chief Justice.
Commissioner Kotsa?
Thank you, Chief Justice, and good morning, Judge.
Morning, Commissioner.
Judge, during the induction of the Judicial Services Commission, retired Judge President Ngwepe reflected on how judges were appointed prior to 1994 and why the creation of the Judicial Services Commission was such a vital constitutional reform. Now, the Commission's responsibility to protect the independence and also the integrity of the judiciary is a duty that obviously cannot be overstated. Over the years, however, there has been litigation concerning the processes, but also the composition of the Judicial Services Commission, the Judicial Service Commission, raising questions about its conduct and that of its individual commissioners. So, to what extent does the Constitution or other legislation speak to the conduct of the JSC and its members or its commissioners, and how, in your view, should concerns about the behavior of the Commission or its commissioners, particularly, or how should it be addressed, particularly when such conduct might place the protection or the credibility of the judiciary itself at risk?
Okay, Commissioner, I'm not sure I understand the question. So how you would like my views on how the JSC should conduct the disciplinary discipline its members?
No. So the JSC obviously has its conduct committee. I'm talking about the JSC as a body, as an institution itself, in protecting the credibility of the judiciary. And in the past, as I've said, there have been complaints about the procedures followed by the JSC or by maybe some utterances by some of its members or some of the commissioners. And there's also been very recent litigation about its composition. Now, how in your view, and particularly when the conduct of commissioners might place the protection or the credibility of the judiciary itself at risk, how should concerns about this body be addressed?
Commissioner, I'm not sure whether the JSC has a code of conduct, which I would say it should just enforce its code of conduct on its members, if there isn't one, be put in place that is made known to everybody, so that when there is a transgression, it can immediately be identified and pigeonholed to the particular provision in the code of ethics or some ethical regulatory framework that the JSC for sets up for itself. I say so because what constitutes conduct that may be reprehensible may not be uniformly understood by members of the JSC itself, the committee, and just members of the public. So I would say it would be important that, first of all, the do's and don'ts are sort of set out in an understandable way. I know it can't be a comprehensive and all-inclusive, but there must be upfront, like we do in all laws, that people must know how they are supposed to behave. And when you don't regulate a conduct, it becomes very difficult to do it sort of pay as you go.
Inkosi Nkonkonyane.
Thank you. Good morning, CJ, again. Good morning, Judge.
Good morning, Commissioner.
It's one question from me. I have had a look in your impressive CV as well as all your judgments, particularly your expertise and your passion in commercial as well as in environmental law. But I may have missed it. I have not come across the other aspect of the law that the majority of South Africans live under. That is African law, customary law, indigenous law, call as it you may. But I was impressed when you indicated that you served in the African Judicial Body. Now, my question is, in that body, did you acquire anything that will be of value if you are appointed to the position you aspire to be appointed by us? Thank you, CJ.
Commissioner, I would only say, in as far as we shared our jurisprudence in that forum, then pertaining to matters of the environment, I did learn how they approach their cases, and in most of the countries, the right to a healthy environment is also enshrined in their constitutions. But I would say that the rate of litigation and how the extent to which issues that pertain to the right have not been as litigated as they have been in this country. Nevertheless, you become aware of what are the issues that are occupying the courts in other countries within the continent, and the approach to their jurisprudence, what that is. So that's what I would say I came up with. Thanks, Commissioner.
Thank you, CJ.
Yes.
Thank you, Chief Justice. Good morning, Judge Dambuza.
Morning, Commissioner.
Judge Dambuza, I know that you've written extensively on the right to a clean, healthy environment, and you've also presented papers on the topic. In the South African context, do you see that right as being a constitutional law right or an international law right?
It is, I think, a bit of both, in the sense that what impacts on that right can be a matter of domestic, but largely a domestic right, in the sense that the Section 24 imposes a particular duty on this state, our country, our government, to ensure that the right to a clean environment is protected, which obligation is not there in as far as a neighboring state might be engaged in harmful practices that impact similarly or to the same extent or even more on citizens within the country. So it is a right that straddles domestic but lies in the main, and the justiciability thereof lies within the country.
You see, Judge Dambuza, I was more interested in probing the extent to which the specific formulation of Section 24A and B, the extent to which that recognizes the right to a clean, healthy environment.
You are interested in the extent to which the right is protected in Section 24.
The extent to which the right to a clean, healthy environment is reflected in exactly how Section 24A and B is formulated. Because you would know that it's a very specific formulation for 24A. It imposes an obligation on the state which is not subject to reasonable measures. And 24B, which is the sustainability aspect, is subject to reasonable legislative measures.
Yes.
Now, I just want to understand, and because you've repeatedly referred to your expertise on the right to a clean, healthy environment, how does that interface with how our Section 24 is formulated and the differing obligations on the state under 24A and 24B?
Well, 24A establishes the right that is not harmful to the health, and B is the portion that then provides for how that right can be asserted. I'm not sure whether I'm quite getting the nub of your question. How that right can be enforced vis-a-vis the government.
And in terms of the content of the right, do you
Yes.
see a difference between 24A and 24B?
24A establishes the content of the right, that you have a right to this, a clean environment. 24B provides a method of enforcing the procedural aspect of the right. I see I'm not getting to where you want me to get,
Not
Commissioner.
really.
I'm so sorry.
No, I just want to, the last follow-up, and then I'll leave this topic, Judge Dambuza. When 24A protects the right of everyone to an environment that is not harmful,
Yes.
and not harmful to their health and well-being, so it's framed in the negative. Do you equate that with the right to a clean, healthy environment? And the reason I ask you this was during the drafting of the Constitution, this was a very live issue, whether or not the Constitution should protect the right to a clean, healthy environment in a positively framed, but what you eventually ended up with was one that is negatively framed. Is there a difference in the two formulations?
In the way, there might be a difference, Commissioner, but I think in the way that our courts are interpreting the right, the difference between, it's sort of an interpretation that translates to a right that acts that are harmful to the health and well-being because of the manner in which the environment is treated are not. You see, a right to a clean environment goes beyond further than a right that is, because the non-harmful aspect of the provision means that you've got to show that there's harmful, but how the courts interpret it is that not only show overt harmfulness or harm, but also the potential of harm. So you get closer to the right to a clean environment. A clean environment or a non-clean environment could be not justiciable because there's no, it's not provided for, in the Constitution. Then one would go to other acts, the talks that regulate, perhaps, for example, pollution and the Climate Change Act to sort of get to the right to a clean environment. In other words, the legislation that has been enacted to advance this right go further than not harmful, to require a right that, to regulate a right that is close to a clean environment.
Just in the interest of time, I'll step off that question, Justice Dambuza, and just go on to my second question. You'll know that on the 9th of August this year, something very significant happened in our country, in that the judiciary adopted its sexual harassment policy.
Yes.
And the JSC just yesterday established a subcommittee which will focus on sexual harassment and on addressing any issues that flow from the implementation of the policy. Now, in your view, what do you think the stumbling blocks to implementation of the sexual harassment policy are?
The biggest stumbling block is people not coming forward to report incidents of sexual harassment, in my experience. That is what causes this practice to be more and more pervasive and just to go unchecked. I suspect we need to do more in supporting victims or survivors of sexual harassment to come forward. Because until the perpetrators actually see people being held accountable, it will, we're still going to struggle to make a significant impact on this scourge.
And if one considers that the new sexual harassment policy is a break from the past, what do you say should be done to encourage more people to come forward to report incidents of sexual harassment?
I think the policy does have provisions that provide for communication that would be protected, that would then encourage victims to come forward. But I'm afraid, Commissioner, I'm a bit tentative because from other initiatives that I have been involved in, particularly with the universities, it is very difficult to get the victims to come out one way or the other. So it's difficult to say any one measure is sure to result in a visible improvement. But we've got to keep on trying. We've got to keep on pushing. It's going to be interesting what the sexual harassment policy yields, because there hasn't been one before. And I'm optimistic that it will result in some measure. And then we can improve from there. A measure of confidence by the victims in the system, in the platforms that it provides for. And then it can keep on being strengthened. But it is a huge development in that sphere.
Follow up, CJ.
Yes.
Judge Dambuza, what are the structural issues that you attribute? I mean, the policy is new, but the issue of sexual harassment is a question that has engaged the sector, the judiciary. And you speak to the reluctance of those who are offended or the victims to come forward, and the difficulty with getting them to come forward. But I would be interested in understanding what are the structural, institutional issues that make it difficult for people to come forward. And having considered the policy, the newly launched policy, do you find that it seeks, and how does it do that to address those structural issues?
Structurally, there was no defined avenue of making a report that one is sure will be taken forward. So you depended on, I think, the informal reports that you would make to your colleagues. You depended on how that report would be accepted, and there was no pathway to getting that is open and known to everybody, that is designed to take people's experiences through. The hope of knowing that now there is a procedure that I can follow up, and if there isn't progress, I can go to a particular person to make a report, is a significant enabler to a person who has experienced sexual harassment, I think. So structurally, the policy itself puts in place a structure that is designed to ensure accountability to people who perpetrate the sexual harassment, I think.
And ensure accountability and put in place measures that will reassure complainants, victims of the sketch to come forward.
Yes.
But we're not going to get into the fine detail of that now. So it's a
Yes.
very complainant user-friendly instrument.
Yes, yes, yes.
Guy Toby, followed by Commissioner Steinberg.
Do you want to go first? Commissioner Steinberg has been itching to speak.
Many minutes.
I'm assuming that from your enthusiastic raising of your hands, that these are follow-up questions.
No, no, no. They're not-
Oh.
not-
In
mine
that
is not a
case, you have to
follow-up.
join the queue. I'm sorry. Is yours a follow-up? We can go back because your hand was up. Put it, please, Commissioner Steinberg.
Good morning, Justice Dambuza.
Morning.
Just before I ask my question, which is a follow-up on Commissioner Singh's question about Section 24 of the Constitution. Certainly from my experience at the bar, it seems one of the more elusive problems we have to deal with to encourage women to lay their complaints and come forward and see them through is the fear that, for example, at the bar, that they will no longer be briefed, that senior male advocates will choose not to work with them. And I think there's real reason for that fear. And I find it quite perplexing as to how we solve that problem, how we create an environment in our spaces where that wouldn't be a normal response and an acceptable response to a woman who's had the courage to speak out. I don't know if you have any ideas or response to that.
Providing a platform to talk, I think could be one of the ways. In other words, providing a platform that potential victims and normally its entrance into the profession. I know that because when I was a practitioner and wanted work, there were advances like those. Creating a sort of, I'm talking about a start. Creating an environment where people can be open and talk about their experiences, I think would be a start. An environment which would include senior members of the profession, some of which would share their own experiences and enable people to talk, and also letting it be known that this is what we are doing. I think would be a way of discouraging the practice and doing it as a forum that is openly known that there is this project of enabling people to talk, because we would really talk about amongst ourselves, and then that would dissipate until you have another experience, and then But where there is a structured, even if informally, where people can talk, and so that first of all, I think there is the affirmation in numbers, knowing that I'm not the only one, because one might be thinking that I'm the only one who is subjected to this kind of behavior, and often there would be known common perpetrators. But if there's not a concerted, if there is no concerted platform, people can know, but people don't feel that affirmed to talk openly. And then the next step is to hold people accountable, knowing that I'm not the only one who has named this person or has named my person. There's another one who will be held accountable as well. Trust is a big issue in these processes as well, because I may talk to you, I have to trust you to be able to know that you're not going to go and tell the very perpetrator that this is what I'm saying about them, because you know the perpetrator in a different light, and you might not believe me. So, we've got to create trust platforms, or platforms of trust,
Thank you.
as one way,
Just to follow up then on Commissioner Singh's, excuse me, Commissioner Pillay's question. This is the second time I've called her Commissioner Singh. Do you think Section 24 gives a litigant space to come to court and ask the court to oblige the state to take positive steps towards creating a clean environment?
I think so. I think it does. I mean, when the Section 24B imposes an obligation on the state to ensure that the right is enjoyed, it creates, I think, in my view, that kind of space. Although as a society we haven't used it as much as we could, seeing what is around us. But I think the section creates space for that right to be enforced.
Where do you see that? Where do you see that in the section, Justice Dambuza?
I see it in section 24B, that everyone has a right to have the environment protected, and then it goes on. And that the environment is protected for the benefit of present and future generations through reasonable legislative and other measures that prevent pollution and ecological degradation, and then it goes on. I cannot see why that is not an enforceable right.
I believe the Constitutional Court has held that that is an enforceable right. And I think that's possibly the difference between the first and second subsections.
Yeah.
Thank you.
Thanks.
Commissioner Shabangu Ndawe.
Thank you, CJ. Good morning, Justice.
Morning, Commissioner.
How are you?
I'm well, thank you. I hope you are too.
My one question has been covered, but I'm interested to get your thinking on this one. There's a perception out there, wrong or right, that seem to doubt the independence of the judiciary. Do you think the impartiality and independence of the judiciary still exists, and how important it is to have an independent judiciary?
Well, Commissioner, I would say judging from the number of cases that continue to flow in our courts, I would say that is a strong demonstration of independence in the judiciary. And also, perhaps it depends on where that general statement comes from and what inspires it. It is, however, still a responsibility of the judiciary as such to ensure that it conducts itself in a way that engenders trust in the judiciary, because that is the big basis of our legitimacy as the judiciary. So I think the statement that there's no trust in the judiciary is not accurate. But I think we still have to keep ourselves, check and balance ourselves to ensure that the trust that is still demonstrated in us endures. I do not get the sense that people come to our courts because of nowhere else to go. I get the sense that they, by and large, I'm not saying that there are no exceptions, by and large, they approach the courts because they trust that that is the best place to have their disputes resolved, their rights protected. That's my view.
Thank you, Justice. Thank you, CJ.
And it's quite interesting to sometimes see the most vociferous critics of the judiciary, when they have their own trouble, speak on public platforms threatening to come to this very court. So I would say, by and large, confidence in the judiciary is still intact. Commissioner.
I agree, Chief Justice. If you remember in the late 2000s, the sentiments, or maybe, yeah, in the 2000s, at some point, the sentiment comes in waves depending on, what has happened in a particular time. But I was pleasantly surprised after some period of hostile statements towards the judiciary having been made, and after some judgments, when the court leaders walked into parliament and they got a standing ovation, and it was patently from some of the quarters that had been feeling very strongly that the judiciary is not worth the country's respect. So it changes from time to time.
Commissioner Ngcokaitho.
Thank you, Chief Justice. Look, on this last point, Justice Dambuza, I think one must distinguish between a popular view and a populist view. For the most part, it's the populist views that we must close down the judiciary and run everything by parliament.
Yes.
But so far, most of the legal questions have focused on Section 24, but I just want to shift the focus maybe to Section 26 and 27. Which are the socio-economic rights provisions. Well, I suppose some people say also Section 25 is a socio-economic right, and Section 28 and Section 29. But the core of it is 26 and 27. Now, bearing in mind that we don't have an economic clause in the Constitution, do you think that these sections can anchor an argument in favor of economic equality? And how can you do that as a judge of the Constitutional Court? What are the sort of creative interpretation lens that you can put on that to move beyond the stalemate of an apartheid economy that we've inherited?
Section 26 and 27 anchoring
a right to economic equality.
Well, the right to housing and the right to health care.
Well, I mean, they would say it's
economic
access to
in
housing.
what sense?
They won't say it's a right to housing. They will say it's access to housing, the conservative readers of the Constitution.
But what do you mean when you say right to economic activity?
Well, to economic equality, and what role a court can use those sections to ensure that we have economic equality in the country. In other words, we end inequality. You don't have to confine yourself to 26 and 27.
Yeah, because I was thinking of the equality clause itself, as to why it can't anchor any articulated right in that direction.
All right, well,
Why?
let's work on Section 9 then. How can it anchor a right to economic equality?
Well, given that it won't be brought to the court on its own, on a particular context in which it is brought, I do not see why it cannot, and it will be brought for the purpose of advancing the right to economy. I do not see why it would not do so successfully in a given context.
Yes. So you see the right to economic equality as implicit in the Constitution?
I think equality cuts across the board. It could be in the housing, it could be healthcare, it could be in other amenities. It could be in business, it could be in economic. I think Section 22, what does Section 22 talk to?
Section 22.
Freedom of trade,
That's the trade,
occupation, and profession. Yeah, I remember that there's some. You know, that's an illustration. This Section 22 already goes towards affirming a right to equal access to economic activity.
Yes, yes, yes. I mean, you don't have to bind yourself on this, but I am trying to answer many critiques about the economic poverty of the Constitution and ask whether or not in other sections of the Constitution it's not implicit that there is a right to economic equality. And so you would say there is, or you would say there isn't?
There is.
Yes.
There is. There is.
Yes, thank you. Well, I'm bringing the next case then, as soon as you are appointed.
Okay.
Then there is the question that has been discussed about delays in judgments. I just don't want to leave that discussion in an unhappy place, that the judge couldn't explain her delays in judgments and therefore is not giving us an optimistic view of what she will do when she's a judge of the Constitutional Court. So can you just clear up that issue? This is a future-looking appointment, not necessarily a past-looking appointment. In terms of explaining the constraints, I understand there are constraints generally that the Chief Justice was talking about, but maybe there are more specific constraints that you've encountered and how you are going to deal with those, because I don't think the litigants will accept an argument that delays in judgment is an integral part of appellate practice. I think that answer won't cut it among the litigants. It might cut it among the lawyers and the judges who work in the system. But I think the litigants will say, but that's unacceptable. So I just want you to give us a more optimistic note about the future, what kind of measures you are putting in place to solve that problem.
At a personal level, Commissioner, my first step was to be asked to be excused from extrajudicial responsibilities, which has happened, but it did not immediately happen. For example, with my work in the Judicial Education Institute, I could only be released in 2023. And also with the Judicial Conduct Committee, whilst I had been released, I had huge mountains of the judicial judgments that I had to write in the Conduct Committee. So releasing oneself from such commitment does leave room. I had asked to be released from the Rules Board as well, and the process was in the way, but the person who was my deputy was supposed to take over from me, assumed duty as the head of court in the Western Cape. But structurally, that at a personal level, that is what one needs to do, particularly when one becomes a senior member of the court and is expected to perform extra duties. Structurally, in the SCA, President Mulimela has said on many occasions that we need researchers. There's 26, 27 judges in that court that have had to share 7 judges, 7 researchers. It is something that she has been trying to get a headway on. To some measure, she's managed to get more, and from, I think, next term, we're going to have 17. But when a judge has to do all that work, and even the small things like proofreading and no support whatsoever regarding research work, things take longer.
And I suppose it's 7 researchers shared among 27 judges.
Yes.
Versus, I think, 3 researchers for 1 judge in the Constitutional Court.
I don't want to go that far.
2, Commissioner.
2. Oh, I thought
but still,
okay.
a judge gets their own researcher.
Yes, or a 2 for the Concord. So
Yes.
at least you'll get someone to do the side checking and stuff.
Yes.
Yes, all right. Then finally, you were asked earlier about whether you introduced any improvements when you were chairperson of the Council of UNITRA. I can confirm, given that I am the current chairman, that you did improve
Thank you.
the standing of the university. So it's much better than it was when you were, well, I don't know. When you left it, it was stable and financially stable.
Yes.
I think for the last 4 years, have had good audit outcomes, and it's thanks to the foundation you laid.
Thank you.
Just one quick question from me. I hope it will be the last one. You're running way behind time. It's an issue that's gnawing away at us. There's a strong push from linguistic communities for the heads of court to revoke their resolution to have English only as the language of record in South African superior courts. And I pose this issue to you as someone who's sat in leadership, in judicial education, and most importantly, someone who's actually sat in a matter in which a bilingual judgment was, English is a closer judgment was produced at appellate level at the SCA, and you actively, but we all participated in that, and so you know how difficult an exercise that can be. I just want your view on how, firstly, important and feasible it would be to accord all our official languages the status and respect which Section 6 of the Constitution enjoins, they should enjoy.
Chief Justice, I think feasibility in context, I think it can be done. I don't see why we can't, if for example, it starts regionally with provision for official languages in a particular, say, providing for 2 languages per region for use in court. All that, I think, is required is resources, and I think it would be huge resources. Presently, or the last I knew, I was aware of, our high courts have not enough interpreters, number one. And then, if that is the case, then one anticipates that there would be a bigger challenge with resources that would enable the court and the judgment to be expressed in a particular language, indigenous language, and then translated for the appeal courts to be given that the judges of those courts come from different language-speaking backgrounds. But if one looks at the international courts, one sees that this can be done. People coming from different countries and witnesses as well that sit and give judgment that is immediately translated for each of the judges to be able to understand it. It can be done and should be done. The challenge is the resources to do it. And it can be done incrementally from the regions until there's a widespread of the practice, I think.
Yeah, you're quite right. It boils down to resources ultimately. The issue of AI was discussed at the recent J20 summit late last month. And it arose during the discussions on that aspect that actually with court online, it would be eminently possible to have automatic translations into as many languages as the user chose. So it appears that it's something that is quite possible, but then we're still taking very small baby steps, literally, as we venture into the age of technology. So one hopes that in that
I suppose
area,
it also goes back to Commissioner Hassan's question on the use of technology. See, yes.
but something worth thinking about. Hopefully, we'll discuss it more at length with more thoughtfulness and solutions when we have the judges' conference next year. Any more questions for Justice Dambuza, colleagues? No? All right. That's the end of your torture. Thank you for a thoughtful interview and for making yourself available for this, Justice Dambuza.
Thank you, Chief
are
Justice.
free to go.
Thank you, Commissioners.